The broadcast is now starting. All attendees are in listen-only mode.
Hello and welcome. I want to welcome you to the Micklin Law Group's monthly webinar series. My name is Brad Micklin. I'm the lead attorney and managing member of the Micklin Law Group, and this is our monthly webinar series. Today's webinar is Are Text Messages Legal Evidence in a Jersey Court Proceeding, specifically family and divorce, which although the title doesn't include that, family court is encompassing both non-matrimonial and divorce cases. Family court proceedings in New Jersey are subject to strict rules of evidence. In this presentation, we'll explore the admissibility of text messages as evidence in these proceedings and the factors that may affect their admissibility. The purpose of this webinar is to help people, especially those without lawyers, in a world with ever-changing, rapidly changing technology. You will find both in this webinar and if you do have to go into a court proceeding that the rules of evidence that are on our books were created long before the internet, email, and even fax machines. And while they are updated almost annually for minor language changes and non-substantial updates to follow developing case law, in my experience, these rules, as well as most of the other court rules that apply to litigation, are not updated as quickly as technology updated. Currently, and this webinar is being typed in or recorded, taped, tells you my age, recorded in June of 2023. So as a caveat, if you're watching this at any point substantially later than June of 2023 and it's being recorded in and pursuant to New Jersey law, so if you're outside of the New Jersey jurisdiction or at a later date, please check with an attorney to see if this applies to you or if it has been changed in any way. But going back to the basic topic, as we see developing technology like cryptocurrency, 3D printing, artificial intelligence, we're going to see a rapid change in the types of digital evidence that can be presented to a court. And this webinar is going to cover what I believe to be the most prevalent currently, which is text message for evidence in court and trials. As I said, my name is Brad Micklin. I am the lead attorney and managing member of the Micklin Law Group. We are a law firm concentrated in empowering men and fathers in divorce, custody, and family law matters, with offices in Nutley, Montclair, and Saddlebrook, New Jersey. The screen that you're looking at has a QR code that will link you to my virtual meeting calendar. If you are a current client, that is always accessible to book a time slot to discuss any matter regarding the case. And if you're a potential or new client, you can certainly use that to gain an open spot, and then my office will follow up with you for an intake to make sure that you qualify and that we can help you with your matter. Here are some of the awards I've been honored to receive, both from outside third-party sources, client nominations, and even peer reviews. I post them here not to impress people, but to impress upon you the length and quality of the work that I believe my office and I provide is one that you can certainly rely on. And when you listen to the contents of this message, you can trust that it's coming from an attorney and a law firm with substantial experience in these matters. I also serve from time to time as a national legal consultant. Here are some clips from Inside Edition, Fox News, Larry King Live, may he rest in peace, I-24 News, and I've done many others. You can see clips to my interviews on my website, which is micklinlawgroup.com. Also, I believe some, if not all of them, also appear on my YouTube page, which is Brad Micklin, M-I-C-K-L-I-N, for those that want to get additional information both on my experience as well as some of the videos I've done on other topics. Again, I don't put this up to impress people, but to impress upon you the wealth of experience that I bring to this webinar and the legal work that I do for my clients. New Jersey Family Court Overview. Types of cases heard. New Jersey Family Court hears cases related to divorce, child custody, child support, spousal support, and more. Inside of the different types of cases the courts hear, you will know, or you will soon learn, that the court has many different divisions to hear these cases. Most have their own specific division. There is a dissolution division, which is for marriages. It represents the dissolution of a marriage. There's non-dissolution, which is obviously many things other than a divorce, which would typically include child custody and support. From time to time, there's also spousal support for people not wanting to get divorced. But I personally have a conflict with the way courts do it. I think it's a misinterpretation of the law. It's outside the scope of this webinar, so I'm not going to touch upon it. But just so you're aware that there is that issue. Going back to the divisions, there's also a domestic violence division and a child in courts, which generally handle DCP&P, formerly known as DIFAS cases, and similar matters. Fortunately, all of the divisions, as well as all the county courts throughout New Jersey, unlike New York and Pennsylvania and many other jurisdictions, they all follow the same rules of court, so that the information that I'm presenting today, as well as the information you may get online, if it's reliable, will be the same for every division and for every county that you go into. Judicial proceedings. Family court proceedings can be contentious and emotionally charged, with strict guidelines and procedures to ensure fairness. Inside of what we hope to be an equitable or fair process, the courts actually have promulgated or written and produced rules of conduct for litigants, rules of code and conduct for attorneys, and even for the judges. Now, they may not be the easiest to find, but usually, at least I know in the northern counties of New Jersey, where I primarily practice, you'll often see these posted on the walls, especially those that pertain to judges' code of conduct. And I say this because I know many litigants are often extremely concerned for how to handle and speak before judge if they are without an attorney or even those with an attorney answering questions. Litigants are often concerned what the judges will think of what they say or do inside and outside of court, and they're generally very uncomfortable with this, what I call the sign of authority that judges hold. So please know that judges also are held to a certain code of conduct regarding candor and fairness to litigants. So don't be afraid to speak up if for some reason you feel that those rights or that conduct is being violated. Lastly, purpose of family court. Primary goal of family court is to protect the best interests of children while resolving disputes between family members in a fair and equitable manner. The important thing to realize about this, and I find myself preaching on a soapbox to many lawyers and even judges, that when they speak of the best interests of the children, the two most important words are best and children. Because people will often come into the case asking for a change, saying it's best for the children, when it's really not. It's either better for the parent or it's good or better for the children. But arguing something is best for children is exceptionally challenging standard to meet, and often not really what is being advocated when somebody's trying to change a custody agreement or court order. Legal evidence in family court proceedings. Types of evidence. There's oral testimony, written statements and documents, expert reports, physical evidence, digital evidence, the topic of this webinar, and more can be all admitted as evidence in family court proceedings. Admissibility standards. Legal evidence in family court proceedings must be 1, relevant, 2, reliable, and lastly, authentic. Judicial discretion. Judges have discretion to exclude evidence that may be prejudicial or unfairly prejudice one party, even if it's relevant. And lastly, the importance of evidence. Given the high stakes involved in family court matters, strong and reliable evidence is crucial to obtaining a favorable outcome. Now, regarding the types of evidence, there are many types of digital and, well, as other types of evidence that are not specified in this slide for you. This is just a general overview. Don't think because you're trying to use something in court that may not appear on this list that it doesn't apply or can't be used. Two, when you're talking about admissibility standards, these are the basic rules: relevant, reliable, and authentic. Each one has a body of case law behind it to determine what is and isn't relevant, reliable, or authentic. Each one is equally as important. So if you happen to be presenting something on your own, you should do what you can to read up on these three different standards so that you understand them, at least the basic principles. Because what's important is you'll see when we talk about different specific rules, and in a second, there are a lot of exceptions to the rules and a lot of ambiguity. Understanding the basic premise behind those rules and these specific three aspects, relevancy, reliability, and authenticity, will help you when you need to argue something that may not be clearly defined in a rule that you want to admit something. Lastly, judicial discretion. Here, the judges have discretion to keep evidence, even if it's relevant, reliable, and authentic, if they think the probative value is outweighed by its prejudicial value, meaning it's more harmful than helpful. This is hard to give an example. It's sort of a case-by-case analysis. When it comes to family court matters, I have rarely seen a court prohibit to rule an evidence piece is admissible because they thought it was unduly prejudicial. This is more common in a criminal matter, but it still does apply to family matters, so you must understand that. And when we speak about rules of evidence, the principal rules of New Jersey court evidence is Article 4 of the New Jersey Rules of Court, specifically rules 401, 402, and 403, will help you better understand the relevancy, reliability, and authenticity requirements. Text message, admissibility, and family court. Types of text messages. Text messages can be personal, professional, or business related, and can include conversations, photos, and other forms of communication. Sorry that was cut off in the screen. And the text messages also can be from different sources. As I mentioned at the opening, as technology develops, social media platforms are ever-changing, and new forms of communication are constantly in development. You could use phone text messages like an iPhone. You can use computer screenshots if you have a messenger app, iPad messages, or any other device that has a capability of exchanging messages, even emails, although technically not text messages, of course, but of a similar nature when it comes to the issues that we're talking about here. Factors for admissibility. The admissibility of text messages is determined again by its relevancy, reliability, and authenticity, and the context in which they were created. Lastly, impact on cases. The use of text messages as evidence in family court proceedings can have a significant impact on the outcome of the case. So please pay attention to the information in this webinar and the rules and cases that are mentioned so that you can be best prepared if you are bringing these issues to a judge in your future. Other considerations for admitting text messages as evidence in New Jersey family court proceedings. First, privacy concerns. The court may consider the privacy rights of the parties involved when deciding whether or not to admit text messages as evidence. This will be significant if you have text messages that involve children that mention the names or addresses or locations of children, for instance, if they're mentioning where they go to camp or where they happen to live. It may also protect if there are other parties being mentioned. There also be communications between other parties. There could be text messages in between and with the children. And children and other parties, let's call them non-parties or third parties, have the right to be protected from having their communications exchanged in a family court, many of which are open to the public and could be viewed and listened to by other people. Chain of custody. The party seeking to admit text messages as evidence must establish a reliable chain of custody to demonstrate the authenticity of these messages. This is very important when it comes to videos and other recording devices, which may be how you're presenting a text message by a photo or a video of that text message, and even as well as if you're admitting videos and text messages, again, which are obviously digital technology pieces of potential evidence, but not specifically text messages. That's the subject of here. But chain of custody basically means you need to be able to establish that it has not been altered from the person who first created the message to the time and the person who's presenting it in court. Now, that may be the same person. If it's your text message, it could be your lawyer if it's your text message. But then you have to establish from between the time that you made the message and created whatever it is that you or your attorney or somebody else is presenting in court has not been altered in any way. Relevancy and materiality. Text messages, as I keep saying, must be relevant and material to the issue being litigated in the case. The reason I keep repeating that is people often don't understand what is relevant and material. If you're in family court, believe it or not, text messages showing somebody is a good or bad person is probably not going to be relevant in most matters. Not all matters, obviously, that's important. And there's exceptions, like there are for most rules. I'm not talking about if your case is about a good or bad person, if it's a domestic violence and you're trying to show a history or a propensity of bad acts of violence, maybe. But generally speaking, when we speak about keeping in mind relevancy and materialities, because people often confuse issues of relevancy and try to admit things that are not relevant, which takes time away from the actual important issues and frustrates the process. And the best evidence rule. The court may require the original text message or a copy of the original to be admitted as evidence rather than a screenshot or printout. And that goes back in part to the chain of custody issue, but also to authenticity, which also is an important theme that we keep talking about. Having a snapshot doesn't guarantee that the court is getting the full message that's contained in that snapshot. It doesn't prove that it hasn't been altered. It also doesn't include, usually, the entire conversation. So when you speak of the best evidence rule, that more often than not means the best source for the information being provided. Like if you're coming in with a photocopy of a picture of a text message, which I've had clients try to do in court, because the photograph is going to be a different quality than the original. Oh, I'm sorry. The photocopy is going to be different because it took a photocopy of the picture. The picture may be of a lower quality than the original text. So now you're 3 levels removed from the actual original piece. And the court may want to see the phone itself, or the device, I should say, that the message is coming from. There haven't been a lot of cases that have dealt specifically with the issue of text messages and admissibility in New Jersey. Because again, it's as far as law goes, a relatively new concept. This technology being so widely used and adopted so broadly, I should say. Not the technology has been with us a long time, but its wide use has increased substantially in the last decade, let's say. Here's a case: State versus Dominguez. New Jersey court expands admissibility of text messages as evidence. In a recent decision, the New Jersey Superior Court expanded the admissibility of text messages as evidence in criminal trials. The court held that text messages can be admitted if they are relevant and authenticated, even if they were obtained without a warrant. The decision has implications for both criminal and civil cases involving text message evidence. So then that's why I have it here. Most decisions that come down in the criminal part are still going to be binding to the other parts, like the family part, the general equity part. Now, what's important here is this case that I'm mentioning, at least that this quotation is coming from a Superior Court case, which is only persuasive in other Superior Court cases, because the Superior Court is the court where trials are heard. So if you're in a family court matter, you're going to be in the Superior Court. There's a higher court called the Appellate Division that reviews the Superior Court decisions, and if they are erroneous, will change the decisions and explain why. The decisions by that court, the appellate court, are the ones that are legal and binding on the other lower courts like the Superior Court. So Superior Court decisions, in short, are useful when you're in the Superior Court, but appellate court decisions are most important. Now, this case, again, being criminal, when you read the case, if you happen to read the case, which I don't necessarily recommend, turns and discusses more about the search warrant issues and the constitutionality of a warrantless search, and don't touch much on the issue of text message admissibility in any meaningful way that I think will help you in understanding or presenting evidence. Common difficulties with admitting evidence in family court. Admitting evidence in family court can be challenging. Common difficulties include proving authenticity, relevance, and hearsay exceptions. A very big topic we'll talk about in a minute. Family law attorneys must be careful to evaluate the admissibility of evidence to ensure that it meets the court's requirement and can be used to support their client's case. This is even more important if you're representing yourself. So issues you need to be concerned with, as we talked about a little bit when we talked about best evidence, is whether or not you want to bring copies or the original. Another significant issue is how are you going to present this to the court? Are you going to have copies made? Do you have to pre-mark them? A lot of judges are different. Following COVID, technology changed a lot. The courts adopted electronic filing. They adopted Zoom or Teams virtual meetings. And that, in some ways, complicated things like admissibility of evidence, because now you're having to upload them on a device and show them to the court. And that technology is also spilled over into a lot of court proceedings. There are often judges where if you're trying to present a video, for instance, which, again, somewhat outside this topic, but digital evidence related, many will have you project it from one device to the court's device and then play it through that device. So if you get there and you have a video on your phone, you may not be able to actually project it through a third party's device, like a Zoom meeting that the judge sets up. In that sense, it's usually best if you're representing yourself to call the judge's chamber, speak with the law clerk, find out in advance if the court has any specific procedure for playing electronic evidence. Does it need to be pre-marked? And how will the court utilize it? And lastly, whether they want it in advance or not. Sometimes courts will have you actually upload the evidence, especially if it's electronic, before it begins. And lastly, as I mentioned before, make sure that you have access to the entire conversation with regard to text messages. Often you'll be submitting a screenshot, which will capture just a portion of it. That can be overly prejudicial because, first, as obvious, it doesn't include the entire conversation, but also will generally include the portion that you believe is important and not the portion that you don't want the court to hear. And judges understand that. We're going to be favorable in our own presentation, lawyers and litigants alike. Be prepared to present the entire conversation. And on that note, there is an app. It's not an app, actually. I think it's a website. Decipher.com, I think that's spelled D as in David, E as in Edward, C as in cat, I, P as in Paul, H, E as in Edward, R, E as in Edward.com. But I'm not sure because I haven't used it. But this is an app, a website that allows you, I believe, to download text message communications from an iPhone in its entirety and in a much simpler, more condensed manner so that you can get all of the conversation downloaded. It puts it onto paper, which makes it easy to copy and produce and upload. But it also may cause you to run into the issues of the best evidence rule and the admissibility because it may be prejudicial because you can't tell whether it's been altered in any way. Online resources for learning about admitting evidence in family court. If you're looking to learn more about evidence and how it is admitted in family court, there are many online resources available to help you understand the process. Some great places to start include the state court's website, legal blogs, and bar association websites. I always recommend that you consult with an experienced family law attorney for personal guidance. Our website, micklinlawgroup.com, will have a significant amount of online resources, blog posts, videos Our YouTube page similarly has that. You can always do your own legal research. I tell people always to use great caution. There's a wealth of information obviously available, but it is very difficult to know the accuracy of the information you're finding and whether or not it's been changed or updated, even if what you're finding is accurate. The sort of rule that I follow, I was taught back in law school, which was before electronic research was available and we were doing things in books. We were told that when you find yourself coming across the same answer again and again, you're probably at the end of the research. That may be a good guideline to try to implement, but again, with the wealth of information that you may find on the internet, it's hard to say if you ever actually get to that point, but I hope that helps. So here are some online resources for understanding trial evidence, admissibility in family court. If you're preparing for a family court proceeding and want to learn more about trial evidence admissibility, check out the following online resources: American Bar Association, How Courts Work with Evidence; Cornell Law School, Legal Information Institute and Evidence; and lastly, NOLO, Admissibility of Evidence in Family Court. I'm not sure if when you're reviewing this, if you're going to have a hyperlink based on the links here, but if not, just run a word search through any web browser and just type that phrase that you see, and it should bring you to what you're looking for, or if not, something very close to it. Conclusion and implications. Text messages can be powerful evidence. The use of text messages as evidence in family court proceedings can be powerful, given their ability to accurately capture conversations and other conversations. And other communications. Judicial discretion is important. Ultimately, the decision of whether to admit text messages as evidence will rest with the judge presiding over the case. He or she will weigh the factors of relevancy, authenticity, and reliability when making their ruling. Expert legal assistance is the key. Given the complexities of family law cases and the challenges associated with introducing evidence, it's always recommended that parties seek guidance of an experienced family court attorney when pursuing legal options. One part that I want to touch on before we move into its concluding this for today is a topic that's beyond the scope here because this is limited to text messages. But there is going to be a significant issue that you will need to confront with many text message conversations, and that's the issue of hearsay. Hearsay is defined as an out-of-court statement offered to prove the truth of the matter asserted. Now, that sounds like a very simple definition, but it's probably one of the most complex issues in rules of evidence in any jurisdiction. And it has a plethora of of exceptions, both in the written court rules, in the case law, and even its interpretation. So while that is far beyond the scope of this webinar, I certainly recommend you make a mental note of it, you do a little bit of research, and you certainly talk to any attorney that's going to have to represent you, and specifically ask if any of the text messages or other evidence that you may be seeking to admit is hearsay and whether or not there is an exception. Lastly, contact the Micklin Law Group. If you need legal assistance with a family matter in New Jersey, contact Brad and Micklin ESQ and the Micklin Law Group. You can visit our website at www.micklinlawgroup.com or check out our YouTube page for more information. Our experienced attorneys can help protect your rights and guide you through the legal process. In conclusion, I want to leave you with a legal disclaimer for the information on this website. Please note that the information contained on this website is not legal advice and does not create an attorney-client relationship. Any information provided is intended for advertising purposes only. You should consult with an attorney for advice regarding your specific situation. This video contains attorney advertising material. The information you obtain at the site is not, nor is it intended to be, legal advice. You should consult You should consult an attorney for advice regarding your individual situation. We invite you to contact us and welcome your calls, letters, and electronic mail and communications. But contacting us does not create an attorney-client relationship. Please do not send us any confidential information until such time as an attorney-client relationship has been established and we request that information. That being said, I hope this webinar information helps you. If you find yourself in a family court matter with text messages to admit, I certainly hope this helps you establish that point. Good luck to you and stay safe.